Yes, we are live now.
It doesn't seem to be so. I'm keeping a tab with the...
Oh, we do are live. We have the tag there.
Well, in this case, perhaps I should wait a little bit more until some more people join us before starting to speak. Okay.
I think it's a good idea.
Yeah, especially because we seem to be having some... Yes. Arthur is back with us. Let me just see. We have 18 watching now. 15. It's fluctuating a little bit. Well, perhaps we will just... I think I will start and perhaps people will catch up and they can always rewind and start the video later. So, good evening to everyone. We would like to thank you deeply for your interest in the event. We are extremely happy with the degree of repercussion it had. Firstly, we, the moderators, shall present ourselves and speak briefly about the IHL Clinic's work, and then we will present tonight's guest, Arthur. We would like to point out that questions may be submitted in the chat box on YouTube. Following the guest speech, we will move on to the questions. With this being said, my name is Felipe Gobato Scheible. I am a last semester student at the Federal University of Rio Grande do Sul, and I am a student member of the IHL Clinic. You're muted, Isabel. No worries.
Thanks, Felipe. I am Isabelle Marcondes, and I am also in the last semester of the law school at URGS. Currently, I am the academic coordinator of the URGS IOGL Clinic. And as per usual, while we wait the other viewers to join us on today's webinar, we would like to give a brief explanation on what the URGS International Humanitarian Law Clinic is, for those who are just getting to know us. We are Brazil's first IOGL clinic, and we serve as a center for learning, research, and legal assistance on international humanitarian law, or the law of armed conflicts. Basically, we work on 3 axes. The first one is the one that motivates us, the group's name that is working with the civil society, be in domestic or international tribunals as an amicus curiae or as a specialized consultant on matters relating to IOGL. In this sense, the clinic also organizes events and education activities, such as this one, as a way to disseminate knowledge about IOGL to the civil society. In the view of the rules laid down on the 4 Geneva Conventions of the 1944 and also its additional protocols, we are always in constant defense of IOGL and international human rights law. Recently, we've been working and will submit an amicus curiae in the case of Aldea de los Josefinos versus the Guatemala case in the Inter-American Court of Human Rights. As for our second axis is regards with the research part, we do have a research project right now in collaboration with the International Committee of the Red Cross, in which we seek to identify state practice present in governmental manifestations that may or may not contribute to the formation of international customary rules. And as the third and last axis is concerned with participation in international competitions, we do have the objective of training qualified professionals in the area of international law, and also integrating Brazil in more specifically our university, the Federal University of Rio Grande do Sul, into the international community. We see these participations in those international competitions on IOGL and other international topics as a way of engaging the students in studying and learning in a more practical way. As for today's topic, maybe considering the time, Felipe can introduce us.
Sure. So, international humanitarian law aims to limit the means and methods of warfare and to protect the civilians during armed conflicts. In order to achieve this end, one of the necessary steps is to effectively punish violations of international humanitarian law. The gravest of these breaches constitute war crimes, for which individuals have been prosecuted in multiple international criminal tribunals, be they permanent in nature or ad hoc. Some cases that have taken place in such tribunals have become points of reference for the interpretation of IHL norms and thus effectively helped develop the IHL. Our guest, Arthur, will be speaking on this topic.
And about our speaker today, I'd like to give a brief introduction to Arthur Traldi, that holds a JD in Georgetown University Law Center, and from 2010 to 2017 was a prosecutor of the International Criminal Court for the former Yugoslavia, having also worked in the chambers of the International Criminal Court for Rwanda. He has extensive experience in issues of international justice and the rule of law, including investigation, litigation, and prosecution of crimes against humanity, war crimes, and genocide. We are indeed very happy and honored to receive you today. Arthur, thank you for your willingness to spare some time to attend this webinar. And without further ado, please do have the floor.
Thank you very much. Good evening. Thanks so much for an overly generous introduction, I'm sure, and I'll do my best to live up to it. I think I also want to congratulate, before I start, you and the clinic on the start of your work. I remember the energy that our interns brought to our trial teams at ICTR and ICTY, and I know you're bringing the same energy to all of the exciting work that you're doing now. I'm particularly impressed with the amicus brief that you recently filed and looking forward to reading it. I wanted to start maybe by taking a step back and talking a little bit about the reality of some of the types of cases that we work on in institutions like the ones where I've spent much of my career. And one of the examples that I like to give is a few years ago in January 2014. I visited my first mass grave. It was in a slag heap at a mine in northwestern Bosnia. And at that point, it was a giant pit. It was January, so it was a giant pit full of piles of snow that had built up as people began excavating the areas where the bodies had been. A mass grave is a pretty solemn experience. And this one was no different. It was a collection of the ends of people's lives, a collection of stories, not just of the victims who'd been killed and whose bodies had been dumped there, but of the perpetrators responsible for it, and of the people who had spent, at the point it was discovered, more than 2 decades wondering where their killed relatives had wound up, where their murdered relatives had wound up. And I think about one of those stories sometimes. I picked this one because it's very public. It was on a documentary about the case. And a woman is interviewed on there, and she talks on the phone about finding her father's body with her family. She talks to the camera about how they had lost 32 people in their family in a span of days, and about how the last memory she has of her father is of him sitting out with having coffee with her mother and saying he wasn't going to hide from the soldiers who were coming in because he hadn't done anything wrong. And it's people like her and her father who are why lawyers who do this type of work do it. And in that instance, there are fundamental principles of international humanitarian law that say what happened to her father was wrong, right? And one of the basics is non-discrimination. Based on what he'd said, the use of violence against him was per se unlawful. And indeed, once he was taken away, because he was hors de combat, the use of force against him would have been unlawful in wartime in the first place. And I bring that up not because it's an equally gripping part of the story, but because what your clinic challenges us to do And what we're here to talk about today is to think about what we specifically as lawyers have to say about a situation like what happened to that woman and her father. And it's worth acknowledging that for most of human history, the answer was not much, right? Or in somewhat more memorable Latin, inter arma emin silent legis, right? My pronunciation is probably off, but the Latin phrase meaning, in war, the law is mute. And one of the things that proper enforcement mechanisms, as Felipe rightly accentuated at the beginning, one of the things they say is, no, not quite. Even wars, as the Red Cross is fond of saying, have rules. Those rules are often quite simple about who you can and cannot target for violence. Sometimes more complicated, but always are serious only if there is some mechanism to enforce them. And international tribunals have shown up since the beginning of their existence in situations that had what I think of as a couple of critical factors. The first is the absence of a meaningful domestic mechanism to enforce those violations. In Rwanda, for instance, I think about the near total devastation of the legal and judicial class in the country that would have made, at least in 1995, it very difficult, if not impossible, to try any cases in the country. Obviously, that changed over the years, and the Gacaca proceedings there have received, deservedly, a great deal of international attention. But immediately after the genocide, it would have been impossible to try cases. Or at Nuremberg, when we think about one of the cases that followed major war criminals, the justice case, that reflected that German institutions had been an important part of the Holocaust themselves, by, for instance, imposing death sentences for race mixing, essentially, for Jews and Gypsies who'd had sex with Aryans, things like that. And the second thing I think of as a key feature is we're talking about what are the worst, the gravest of the grave crimes. And often it's hard to think about categorizing or classifying crimes that fit the definition of atrocity crimes, war crimes, crimes against humanity, genocide. But these institutions, of course, don't have thousands of courtrooms. They don't have thousands and tens of thousands of staff, and they don't have mandates that last for the next 500 years. And so there are, as with any court, choices that have to be made, prosecutorial discretion that must be exercised. And so, in my view, what you generally see, quite properly and quite responsibly, is an emphasis on the most serious crimes within a court's jurisdiction. With that said, I want to talk a little bit about the role of these institutions in international humanitarian law, since after all, that's the title of the talk. And I want to start with what I think are two very basic principles about that. The first being the role of these institutions in international humanitarian law has been very substantial. And you see that in practice and in scholarship. For instance, the Red Cross that you all have collaborated with and that is one of the leaders in the world on international humanitarian law issues, puts out papers on different topics in international humanitarian law. It happened that I was reading a paper of theirs this afternoon before we spoke on international and non-international armed conflicts. And literally half the citations were to decisions of the International Criminal Tribunal for the former Yugoslavia, because it's a genuinely international institution that is addressing these issues and making precedent. And also, of course, because citing to it doesn't involve picking one domestic legal system's conclusion versus another. So it may be a little bit more palatable diplomatically to cite to as well. The second thing I think is, and perhaps the two of you are more qualified to speak to this than I am, but one of the roles of these institutions in international humanitarian law, I think, is conveying to people, for instance, by saying, we're looking to hire interns from Brazil, that working in international humanitarian law and genuinely international institutions in cases that cross borders is something that's available for people as a career path. And I think these are institutions that, like any other, are imperfect in making themselves universally available. You see a lot of discussion at the moment on internship programs and the fact that the lack of a budget for them may favor people from wealthier countries, for instance. And hopefully there'll be progress made in that regard. But I think the fact that they exist, even as imperfect institutions, which is what we would expect from institutions run by humans, does encourage people to look at the field as a real option in a professional career track in a way that wouldn't have been as likely in the 1980s, for instance, before what I think of as the contemporary revolution in the enforcement of international criminal law that came with, at the beginning, ICTY being established in 1993, and then ICTR, the Rwanda Tribunal, in 1990. So I think those two are perhaps the two most important. The first being that it does drive a lot of the scholarship because of the international nature and it kind of being a single source. And the second being that it is that it encourages people to look at the field as a real option. I want to attach one caveat about each of those before talking a little bit more about how that's worked in practice. And the first caveat in terms of the prominence of these institutions is it is, of course, the case that the great majority of international humanitarian law litigation, compliance work, training, enforcement is done at national levels around the world. And if we overly focus on what happens in the international tribunals, outside of perhaps a given talk where that's in the title, we'll be missing some of the most important developments in the world, and also losing some perspective from the folks who are actually working with it as they make a difficult targeting decision, for instance. And for the second, I think we're at a bit of a hinge moment for these international institutions, a bit of an inflection point. We've had a quarter century of very active investigations and trial work since the 1993 establishment of the Yugoslavia Tribunal. We have a bit less of that right now. The courtroom component of what is likely to be the last case out of the former Yugoslavia heard at now the successor institution to the ICTY ended just this past week. Closing arguments are expected early next year. ICTR caught one of its last remaining fugitives, so there will be another trial at its successor institution, the mechanism, but just one probably. The Sierra Leone court is closed. The extraordinary chambers of the courts of Cambodia look unlikely to do more cases. So at the moment, there's only a couple of cases genuinely in trial in these international institutions. And many of them are facing choices about where their priorities will be. To some extent, the international community is facing those choices in a way that will affect whether the people who have been convinced that this is a real career track are being convinced of something that's reasonable, or are going to have to look for similarly complex work in their domestic systems, where that work is, of course, necessary and will always be. I'd encourage all of you to think about doing that as a kind of first option. Okay. That said, I want to talk a little bit about what has been demonstrated by these institutions in terms of the law and, perhaps more importantly, the practice of enforcing international criminal law in cases like this. And I'm going to use often the term atrocity crimes, which includes grave breaches of the law of war, as well as crimes against humanity and genocide, because that's what these tribunals were mostly looking at. The International Criminal Tribunal for Rwanda, for instance, was very focused, for obvious reasons, on genocide charges, and it was much less important to look at issues in the law of war as set out in the Geneva Conventions. With that in mind, a couple of things I think come out clearly from practice. The first is these tribunals demonstrated, as a very basic legal concept, that the Security Council has the authority to enforce international humanitarian law and the law against atrocity crimes through setting up fair tribunals to adjudicate criminal cases. That comes from the Security Council's authority under Chapter 7, which all countries signed on to when they became UN members, to identify and take measures to rectify breaches of peace. But before ICTY and ICTR, it hadn't been used to set up criminal trials. And making that recognition of that authority means a couple of things. First, it means it is a policy tool that will be used more often going forward. But second, it acknowledges, I think, the hope and gives legal force to the hope of everyone in the field that post-conflict justice will be a step towards rectifying breaches of peace. And I think it's fair to say that that remains kind of an aspirational idea. If you look at the discussions at the end of the life of ICTY, the legacy discussions, one of the things that really jumped out at me was at one of the conferences in Sarajevo, the then president of the institution spoke, the president judge. And what he said was essentially, we brought truth, not reconciliation. And I'll paraphrase a little bit what came next, but as I understood him to be saying it, reconciliation is kind of your job. And that makes sense. And it would be impossible to expect a group of lawyers 1,000 or several thousand miles away from a conflict to build reconciliation in that country. But there is a valuable, I think, principle of directing culpability at individuals rather than groups, and setting out some type of historical record provable beyond a reasonable doubt that is important, first, for bringing closure to survivors and their families, like the woman I talked about earlier, but second, to building the possibility of a shared understanding of the past and reconciliation on the basis of truth. Okay. Chapter 7. Second, I think we managed to help advance the state of IHL enforcement and enforcement of the rules against atrocity crimes on a variety of issues. And at ICTY, of course, that starts with Tadic, right? The first case at the tribunal to be litigated and the first major appeals chamber decision. And one of the basic, I think, questions that it answered is instructive for thinking about how international institutions handle cases and draw from a variety of different areas of domestic jurisprudence. So, as many of you may have heard, Tadic defined a term called joint criminal enterprise, which was the form of co-perpetration used at ICTY, ICTR, and the extraordinary chambers of the courts of Cambodia, among others. And the judges on that case had to make two very basic decisions. And the first was, does international law recognize some form of accomplice liability? That is, does it say there are situations that when several people commit a crime together, they can all in some form or another be criminally convicted for doing this? And the Tadic Appeals Chamber had to think, okay, we're a new court. How do we evaluate this question? And they started by looking at what seemed like the most similar cases, post-World War II cases from a variety of domestic jurisdictions, considering law from French, Austrian, German, Italian, Canadian, English, American, African, Australian sources, and came to the conclusion that I think is pretty clear and uncontroversial. Of course, sometimes you can be liable for acts you intend and collaborate in, but which somebody else physically perpetrates with your assistance. Okay. That's a colloquial way of saying it. But the second thing they had to do is figure out what are the elements that will apply at this tribunal. And that's the area that's been more contentious over the year. They identified, probably some of you also know, 3 forms of joint criminal enterprise that set out different elements that we would have to prove as prosecutors to hold somebody responsible for crimes. And we all probably know that accomplice liability, while broadly recognized in different systems, takes different forms in different jurisdictions, whether it's American conspiracy law, Australian law that's actually called joint criminal enterprise, the German concept of the perpetrator behind the perpetrator, which I'm going to exercise my discretion not to try to pronounce, or some other type of principle from a different legal system, of which the world has many. And the appeals chamber explicitly considered cases from a dozen countries, as well as the then just negotiated Rome Statute, Nuremberg, Tokyo, and other military tribunals in figuring out what principles ICTY would apply. I think that's useful both in thinking about co-perpetration and how it would be understood in IHL, and thinking about how genuinely international courts would go about answering questions, first in more general and second at more specific levels, about what law would apply. Second, one of the atrocity crimes that I mentioned, genocide, was enforced in an international institution for the first time in the 1990s. And it's broadly recognized by now that the Genocide Convention codified rules that were customary. But it wasn't part of the charges at Nuremberg. And so ICTR and ICTY were defining some of the key terms in the convention for the first time. Most of us are familiar with the key text, right? The reference to the destruction of a group in whole or in part, that chilling idea of removing an entire type of person from the world, an entire community from the world. But I think we can all imagine too, thinking as litigators or law students, the type of people that like to have arguments about what words mean, that part of a group, the language in the convention, could cover a whole lot of ground, ranging from what we might otherwise think of as genocide to what we might think of as a single isolated instance of criminal behavior. Because everything from one less than the whole to one more than zero is a part of some form. And so ICTY had to consider what that part meant. And it looked, as you would in international law, to declarations, reservations, understandings that countries had offered when they signed on to the convention. I seem to have frozen. So apologies
You're doing
for
just
that.
fine here.
Can you hear me?
Sorry.
We
Yes,
can hear you.
we can hear you
Fantastic.
perfectly.
I'll try not to get
You're just
distracted by the fact that my video froze then.
No worries.
So what I was about to say was they looked at declarations, reservations, and understandings. They looked at the arguments of the parties in the case, because they're judges and that's what you're supposed to do. And then determined that what part meant was a substantial part, a part that would have an impact on the survival of the group as such. And at ICTY, the key case on that is the first of the genocide cases at Srebrenica involving General Krstić. And it made clear that the substantial part rule is part of international law and set out principles for determining when the targeted part of a group is substantial. including, for instance, the symbolic value to a group's survival of a part of a group living in a particular area that has historical or strategic or other importance. Akiezu considered two different questions, Akiezu being the first litigated case at the Rwanda Tribunal. The Genocide Convention sets out 5 specific acts which, if committed with the required mens rea, the required intent, constitute genocide. 2 are very simple: transporting children out of a group and into another so the group essentially doesn't have a next generation, and sterilizing people in the group for the same reason. The other 3 are a little bit more complicated, and Akiezu began to define 2 of them. First, and more simply, killing members of the group, and Akiezu clarified that the type of killing at issue is murder. Second, genocide may be committed through, under the convention, imposing serious bodily or mental harm on members of the targeted group. And Akiezu held in a specific holding that I think is really important for the tribunal's legacy and impact on the direction of atrocity crime law, that one of the types of serious bodily or mental harm which could fulfill the actus reus of genocide is rape or other crimes of sexual and gender-based violence. And I think that sounds pretty obvious if we stop and think about it. If you start listing the most serious domestic crimes in your head, I suspect you'd start with rape and murder in one order or the other. But international law hadn't explicitly said before Akiezu that one of the ways that you could commit the crime of crimes, genocide, was through. And following Akiezu, this is why I think it's important for the tribunal's legacy, a large number of cases at both tribunals particularly emphasized crimes of sexual violence. At ICTY, for instance, Kunaritz adopts a charging strategy that had been used in some sex trafficking cases in the United States, and identified repeated crimes of sexual violence against the same victims detained at the time by the perpetrators, over whom they were acting in a way that demonstrated what are called in law indicia of ownership, acting as if they owned victims, as the crime of enslavement. And you see the impacts of this in our policy discussions and legal discussions today, for instance, of ISIS crimes against Yazidi and Christian women in Syria and Iraq. And I think we've seen, too, more generally, that after years of underemphasis, Akiezu, Kunaritz, and subsequent cases really put crimes of sexual and gender-based violence at the forefront of the enforcement of international humanitarian. Third, the tribunals demonstrated international criminal law has the legal capacity and the logistical capacity to hold leadership level figures responsible for serious violations of the law of armed conflict. And in practice, that meant a couple of things. It meant getting custody, which often took a long time. In one case I tried, the defendant was a fugitive for 16 years after being indicted before he was eventually arrested and brought to trial. Second, meant finding ways to bring together enormous amounts of evidence to show massive patterns of criminality, unprecedented except at Nuremberg and Tokyo. Just by way of example, in the last case I tried in The Hague, at the beginning of the public delivery of the judgment, the presiding judge summarized the evidence in the case. And he said that the chamber had received the evidence of about 600 witnesses, that it had admitted into evidence almost 10,000 different exhibits. And he said this at approximately transcript page 45,000. And that's the level of evidence, I think, that has worked in holding responsible, really leadership level figures for the gravest crimes. And there were major successes in that regard. The convictions of some Rwandan government figures for conspiracy to commit the genocide of the Tutsi people in the Karamera case, and of senior political and military leaders in Bosnia and Herzegovina and elsewhere in the former Yugoslavia, political leaders of Republika Srpska, Radovan Karadzic, of Herceg Bosna, Jadranko Prlic, and of Serbia for crimes committed in Kosovo, and Sinovic involving the deputy prime minister of Yugoslavia and the head of the Yugoslav army, among others. And I emphasize those because those are cases, not because a conviction is the right measure of success of a trial, but because it is being able to get some leadership level convictions is the right measure of success for deciding to put leadership level figures on trial. If you don't have the personnel or the resources or the evidence to get convictions in some of those cases, then you shouldn't be doing it. Fourth, I think, we learned how hard it is to hold people at that level accountable. And that's part of why I mentioned the amount of evidence available in one of my cases. And there were also challenges, some related to the quantum of evidence. The 3 non-Caramera cases alleging a leadership level genocide conspiracy against the Tutsis weren't successful in that regard. Slobodan Milosevic famously died during trial. High-level leaders of some accused groups were never convicted, but acquitted in the context of allegations that witnesses had been interfered with or controversy about how the cases were decided. I think that underscores something that perhaps we don't say often enough, sometimes because we're emphasizing what's possible rather than what's happened already. But something that's really clear from our experience at the ad hocs, which is that prosecuting cases at this level is really hard. Lots of things can go wrong. And I want to give a couple of examples of how cases have failed at these international institutions. An appeals chamber decision clarified the elements of aiding and abetting liability in a way that wiped out a conviction and meant for years people had decided which documents to tender and which questions to ask based on a different understanding of the law. A badly written indictment led to some rape convictions being vacated. A written judgment reversed the burden of proof on alibi, leading to the acquittal of somebody who'd been convicted of genocide, something that should have been caught in a site check at a variety of different times during the process. A trial chamber found that a joint criminal enterprise that started off including only some crimes had expanded to include more, but didn't specify exactly when that happened. The appeals chamber decided as a result that they hadn't been specific enough and wiped out most of the convictions in that case. And the lesson I think we take from that is looking at these genuinely leadership level cases, there are no shortcuts. The cases people think about and want to do first and foremost, whether it's against Maduro or Assad or Bashir, are massive cases involving allegations of large patterns of crimes committed by people operating in multiple structures of power, each of which prosecutors and judges have to understand and have to be able to prove in a way that is reliable and will hold up to historical scrutiny. There are no shortcuts to doing that. There's a cliche here in the United States that you may have something similar to it in Brazil. Good, fast, and cheap. You can't have all three. And in a genuinely leadership level case like this, I'm not sure you can have good in either of the other two, in fact. All right, so with those couple of lessons in mind, I think I've talked for longer than I meant to. I'll take a break, and if you can still hear me, my video remains frozen. I invite you to ask any questions that you might have.
Thank you very much for sharing your thoughts on this. We will then move on to a few questions. We, the moderators, have already a few questions, and we also have questions from our viewers. And I stress out once again that if you have any questions, you can submit it in the chat box of the YouTube video, and we will ask them later on. So, Arthur, you have mentioned that the advent of international criminal tribunals has showed to people, especially young people, that international law can be the subject of a serious career. In the last decade, however, many governments have turned to more isolationist and nationalistic tendencies. Do you believe that a change in mentality is due in a few decades, and thus could lead toward a more toward a political future that is more focused on multilateral cooperation?
I think first that there's a little bit of a false dichotomy in how we talk about these things most of the time, that multilateralism traditionally is based on sovereign equals working together and finding that it's in their interest to do so and in everyone's interest to do so. And I think we'd expect different countries to make slightly different choices about different ways of doing that at different times. I don't think it's something that is avoidable on a lot of issues going forward. We just simply do live in a world that's more connected. And what we've seen that perhaps more than ever before this year in how dramatically it's affected our lives, what began as a public health issue most of the world away from us. And I hope that governments will continue to find practical ways of working together in ways that benefit all of us, both professionally and more importantly as citizens.
Very well. Thank you for your answer.
Yes, of
Isabella,
course.
do you want to
We
go
have
forward
another
and-
question also that came in the chat box. That is, you mentioned that the tribunals had to give a definition to terms such as genocide. While it is clear that attempting the physical elimination of a group is categorized as a genocide, do you think that programs seeking to repress elements of groups' identity, such as the language, religious practices, and cultural ceremonies, could potentially qualify as a form of genocide as well?
So I want to answer on two levels. The first is that a lot of things, if done with the intention to destroy the group physically, can qualify as creating conditions of life deliberately calculated to have that effect. And cultural genocide is a little bit more complicated. There are some specific areas where, based on the drafting history of the Genocide Convention, it is less likely that cultural issues will qualify as genocide. The second level I'd answer on is it may be the case, and often will be the case, that there are other violations, not genocide, but the crime against humanity of persecution, for instance, can be made out where the elements of genocide can't. And you see in a number of ICTY cases, for instance, that the trial chambers and appeals chambers found that the elements of genocide hadn't been satisfied, but elements of persecution, taking away a specific right on the basis of discrimination in the context of a widespread and systematic attack against a civilian population, were satisfied. And I think I'd kind of underscore on that point that crimes against humanity are really bad. And it's not necessary for every bad thing to be genocide. Genocide does have this very specific meaning characterized by the destructive intent and the drafting history of the convention. But that doesn't in any way legitimize things that are other types of crimes against humanity, other types of atrocity crimes without being genocide.
Thank you. We received a question in the chat box from Lebanon, which asks about what is the legal qualification of the blast that happened in Beirut in 4th of August this year, both under IHL and under international criminal law?
That's a great question. I don't know the answer yet, in part because I think we're still figuring out some of the facts. There's been good work and good scholarship done assessing whether you can bring the blast within the scope of atrocity law. I don't have an opinion on it myself yet, but I can point Felipe to a couple of the articles afterwards, which you can pass along to you. And since you're writing us from Lebanon, first, thanks for being here. And second, of course, I hope if you're in Beirut that you and your family got through it okay.
Thank you very much. Going on to a next question that was sent in the subscription to this webinar. It is, do you believe that following the advent of international criminal tribunals and their prosecution of war crimes, state and non-state actors have taken more concrete actions to comply with the rules of IUGL? You are muted. I'm afraid you have to repeat because you are muted.
Oh. Well, it seems we're facing a little bit of a technical issue with Arthur's connection. I hope he will return to us shortly. And
I think I have.
There you are.
Sorry about that.
Should I repeat the question? It is written.
I think it's written on the screen. I think in some instances, and I think certainly you've seen increased attention to compliance. I think there are certainly also areas, Syria is one, where there doesn't seem to be an immediate likelihood of enforcement, and people have continued to be able to act with impunity, with really serious consequences for the population. But I think certainly it's become a much bigger part of our discussion of foreign policy, of armed conflict. And I think my impression is, anyway, that you've seen a great deal of increase in attention to compliance by states. And I think that is really where you do save lives, is on the front end through compliance, through training. And it doesn't make for as exciting a discussion as cross-examining somebody accused of genocide. But doing it in advance is where there's really a benefit. And I think maybe I should have emphasized even more at the beginning, I think, as an example of where it's that domestic work that really makes the difference and where IHL has the most importance.
Thank you for your answer, Arthur. We also have another question. You mentioned the Tadic case, which was the first case judged by the ICTY. One of the big changes that happened in the Tadic case was the development of requirements for the existence, or for determining the existence of a non-international armed conflict. Those elements were determined as being a minimal level of organization of the parties and of the intensity of hostilities. Do you believe that the court could have been more precise on these elements, or are they better left flexible?
I think on a lot of these questions, flexibility is really important. And flexibility is important because we have to look at a lot of different facts. And taking all of those together in their entirety, to me, is the right way to judge.
Well, thank you once again for your question. Do you want to follow up on the next one, Isabella?
Yes, this one coming from our live chat box. That is, the ICTY has diverged from the ICJ's understanding on state control over armed groups and apply a lower threshold, that of the overall control test instead of the effective control test. Do you believe the overall control test to be more adequate?
I think I have I probably am a little bit more of a fan of the effective control test. It hasn't been dispositive in a case that I litigated, and so I don't want to claim to be an expert on it. But I think there are probably situations where I'd be inclined to one as more descriptive. And I think generally speaking, I think effective control might better set out our traditional understanding of international relations. That said, I think it's also right to say that one of the factors that makes these cases different is ICJ is not just assessing state control. They're assessing state control for the purpose of ascribing state responsibility, where there's a lawsuit against a state. And ICTY is assessing it for the purpose of simply this threshold armed conflict factor in a case that gives rise to individual criminal responsibility. And so without claiming too much authority, any more than I have, on the distinction between overall control and effective control, I think one of the things that might motivate the different tests being used by the different institutions is the different things at stake in the cases where they're applying those tests.
Fair enough. Thank you very much for your answer. We actually have a question from one of our consultants in the clinic, and the question is: what are the shortcomings of resorting to an international criminal tribunal to enforce IHL?
I mean, the biggest one is it means there's been terrible suffering already and the breakdown of a domestic justice system. Without those two factors that I mentioned at the beginning, you don't really have the basis for calling it an international tribunal unless you're looking at crimes that are the worst of the worst, and unless you're looking at a situation where there's not a meaningful prospect for domestic justice. And so it's always a sign, I think, that there's been a tragic shortcoming in terms of diplomacy and how the situation has been handled up to that point.
Thank you once again. I would like to move on to a different question that was put forward by one of our viewers. She asked, what are the challenges that you see around cybersecurity and prosecuting international cybercrimes?
I'm going to just beg off that time. There are people who are great experts on cybersecurity law. I wish I was. I think it's probably a much more vital and much more lucrative practice area the next couple of years than international humanitarian law, but it's just not my area of expertise.
Well, thank you anyway.
It is very fair.
It is a fair response, really. In this sense, I would like to then move on back to war crimes. There was another question that was made also by one of our consultants regarding what are the differences between the provision on war crimes under the ICTY and the provision under the ICC.
I think the biggest one is, and I think of this more as a litigator than an academic, I think of the biggest one as being a question of the focus and intensity and expertise that one of the ad hoc tribunals could bring over years to really understanding the complexities of a situation and really litigating it with a level of rigor that satisfies you as to the burden of proof. And if I can just digress for a second and point to an ICJ judgment, in the Bosnia versus Serbia and Croatia versus Serbia genocide cases, the ICJ has imposed a standard that appears from its plain terms to be a criminal law standard or higher for holding states responsible for wrongful acts of the magnitude of genocide. The words they use are fully convinced. And really having that type of expertise in the building, having that type of expertise on your team, that you genuinely understand a set of facts and are able to work with them at a level that you can look yourself in the mirror and say you are fully convinced of the allegations you're making, I think is really appropriate and necessary when we're dealing with crimes of this gravity. I think just because they have a large number of situations, I think it's much harder for ICC to achieve that level of specialization and that level of expertise in a given one.
So changing and bringing back a little bit the career part that you mentioned in the start of your talk, someone asked what kind of jobs does the International Criminal Tribunal offer? And if I can add another question to this one, maybe what are the perspectives that you see for us IOGL studies or IOGL interest people in relation to ICL maybe or other tribunals?
Okay, so I'm going to answer what I think of as the less important part of the question first, which is what jobs these genuinely international courts offer. For law students, their international internship projects or programs will be accessible on their websites. I know they try to look to draw people from all over the world and get a variety of different perspectives from different domestic systems within the deliberations in the office. I think it enhances the work to do that. And I'd encourage you, if you're from a country that you perceive as underrepresented there, to look at them and bring your perspective and your background to those institutions. The more important thing, I think, in terms of, let's say, prospects for getting into the field of IHL. As I said during the early part of the talk, I think we're at a little bit of an inflection point for international institutions in this regard. And it's a little bit harder to project than it would have been 10 or 15 years ago what entry-level jobs will look like. Or I guess there are no purely entry-level jobs at these institutions that pay anything. But what junior jobs will look like at the point that those of you who are students in the clinic start to hit the level of experience that's necessary to do them. The reason that I think that's okay in terms of thinking about a career path in IHL is my experience of those institutions and working with lawyers from different backgrounds, different places around the world, is by far the most important thing to do to prepare yourself to do well in a job like that is making sure you're a good lawyer. And that can happen in a bunch of different ways. It can happen through doing huge numbers of witness examinations in court, even in what might seem like relatively minor cases. It can happen through working with judges and getting a sense of what they look for when issuing a decision and honing your advocacy reasoning as a result in a way that you can't get a perspective like that without working with somebody on the bench. But becoming a good lawyer and becoming able to do the job in your domestic system is really essential. And there are things that I had to learn on the fly at an international institution that, I'll be honest, I would have spent a lot more time in my apartment. I would have spent a lot less midnights in the office if I had had a little bit more domestic experience in that regard. But I think there will, in part because, well, step back a second. As a result, I think the things that you should do to become a good lawyer, whether or not there are a lot of jobs in international institutions, are the same. And it's not that much of a worry that it's at an inflection point right now. But the second thing to say is, as we talked about a little bit, and I think one of the early questions pointed at this too, the domestic compliance, domestic enforcement is such a big part of where IHL resources actually are. And conveniently, I think it's the part where you can make the biggest difference. And so if it's IHL as a subject area that you're particularly passionate about, I think there'll continue to be large numbers of opportunities to serve domestically and really make a difference in people's lives by doing it. And we can be confident of that, whichever direction the international courts go.
I think we would like to make a closing question that came from the comments on the YouTube video. This question asks, what is the impact of the International Military Tribunal for the Far East on the current acceptance of IHL and ICL by non-Western countries, especially from Asia? Sorry.
That's a great question. I don't consider myself an expert on it, and so it's Renato. I think if you have thoughts on it, I'd encourage you to share them. I think it's a really important set of cases, and in some ways under-considered. It's an important set of cases on basic concepts like command responsibility, and I'd like to think that it's valuable for acceptance there. I know there are a number of countries in that part of the world, in the Far East, in East Asia, that are among the real leaders on IHL and have produced some of the great folks at the international institutions. I think personally of the current president of the Assembly of State Parties at ICC, who was a judge at ICTY when I was there, a South Korean jurist named Ogan Kwon, who is perhaps the most enjoyable in-court examiner I've ever watched, who seemed to simultaneously have such a gift for asking incisive questions and such a positive manner of doing it that I really admired. So I don't know exactly how much the Tokyo Tribunal contributed to South Korea's role there in international humanitarian law generally, or to the opportunity for it to produce a jurist of his stature, but I'm glad it did.
Actually, I would just like to thank for all of our questions, because we did have a lot of engagement. I hope it is not on the detriment of those questions, but I would like to use this time to pose a question that I thought myself during your talk. I actually would like to question about the ad hoc tribunals. We did have a series of them, mainly before the 2000s, with their background context and, of course, their huge developments for the international law community. However, considering the existence of the ICC nowadays, what would be the role of ad hoc tribunals, if they would still have one or not? What are your perspectives on it, please?
Yeah, I think it's less likely that we'll see a large amount going forward than it would be if we didn't have the International Criminal Court. I think you will still see some, and one example just the last month is we've seen the first arrests at the Kosovo Specialist Chambers, and that's a court that deals with crimes committed, well, with allegations of crimes, I should say. We haven't seen convictions yet, committed before the Rome Statute was in effect. ICC couldn't hear those cases. It may be the case that we'll still see in the future Security Council action in places that aren't member states, like Syria or like Myanmar, for instance. But I think certainly the hope for a lot of people has been that the ICC will serve as the first international forum. I think there's limitations in that regard. There's limitations on the institution, and limitations on its ability to gather evidence, and also limitations on its record. Faces a lot of structural challenges. Good people work there. I know many of them, but it's also produced only 3 convictions in contested trials in almost 20 years of existence. And I think if you compare that to the records of most of the ad hocs, it's not that substantial. So I think you'll see less. you may still see some, and it will be affected greatly by what happens in the next couple of years with the International Criminal Court. And in that regard, I think the International Criminal Court, like international criminal justice institutions generally, is at a bit of an inflection point. It's changing over some of its leadership next year. I think you see really robust discussions of how it should conduct the next 9 years of its mission under the next prosecutor as part of that selection process. And I think those will shape whether there is a role for more ad hoc institutions, how the court decides to handle some of those questions.
Well, once again,
Oh, thank you
sorry.
for your honest question, your honest answer. Thank you.
Well, with this question answered, thank you. I would like to thank you, Arthur, for your attention and for sharing your knowledge with us and also your time. It has been a great event thus far, and I believe we are now about to close since we have reached the 1 hour mark. I would like to also thank all of the attendants for their interest and their presence. I would like to notify the watchers that the live stream shall be posted on our YouTube channel. So if you want to review the event, if you want to get any part that you missed during the live stream, it shall be posted. I will also suggest you all to subscribe to our channel. And I would like to invite everyone to follow the clinic's work through our social media accounts, which will be in the video's description. And with this, I would like
Yes,
to...
I was just going to actually thank Arthur again and make Philippe words mine also. We do know you don't have a lot of time, so thank you for sparing a little bit to attend this webinar. We are very happy for it, and I'm sure all of the attendees are also. So that's it, my thank you.
Thank you for having me and for organizing this, and it's been an honor to talk to you about it and to engage with all of your attendees.
Well, thank you very much. We are having some comments thanking you for the, well, both Arthur and the clinic for the event. Thank you once again. I think we are ready to end this session now. Thank you.